So in this case video, we're going to be looking at the Curro and Beyond Productions case. All right, so this case is an injunctions case, and it also deals with, arguably, a restraint of trade, that is a negative stipulation. So in this case, Curro, a television presenter, agreed not to seek employment elsewhere during a period in which time she was contracted to Beyond Productions. And then she ended up seeking employment elsewhere with a rival channel, with Channel 9. And then the question was whether Beyond could use an injunction to enforce that negative stipulation. Yeah, so here, in terms of her seeking employment elsewhere, there was quite a short period of time remaining on the contract. It was only, I think, about 8 months. So she resigned in January 1993, and the contract was to run until August 1993. And then by the time Beyond Productions brought the injunction action, it was March 93. So it was about a 5-month period. They were seeking to restrain her from working for the competitor, Channel 9. Here, the court at trial granted the injunction, and then Curro then appealed. There were two grounds. The first, that the restraint itself was void as being unreasonable. Restraints of trade are void as against public policy unless they're reasonable, okay, which is the old Nordenfeld test. So she argued that the restraint itself was void, so it wasn't binding upon her. And then in the alternative, she argued that even if the clause was binding, that there was no grounds or discretionary grounds for issuing, or that, I guess, an injunction shouldn't be issued in the court's discretion in this case. And the reason why, the main reason, was that she said that issuing that negative, that prohibitory injunction would essentially force her to continue working for Beyond Productions. So it essentially would compel her to carry out her obligations under the contract. So it would essentially work as a specific performance order, remembering that specific performance for personal services contracts, aren't issued. Okay, so she was arguing essentially that the injunction was being used as a backdoor argument to get her to perform her obligations under the contract. So the New South Wales Court of Appeal held that the clause itself was not void as unreasonable, and that exclusivity in these types of cases involving say actors, presenters, TV personalities is quite normal and quite a legitimate business interest of a company like Beyond. In addition to rejecting the argument on the basis of the restraint of trade clause as being unreasonable, the court also considered whether that clause could be enforced by a prohibitory injunction, so whether she could be prevented from seeking employment elsewhere. And the court here said yes, an injunction was available, and there was a number of grounds which are noted here on the slide, okay? Including damages were not an adequate remedy because exclusivity can't be compensated and reobtained elsewhere once it's gone. It was a relatively short period. It was only a 5-month period. They were seeking to restrain her. Her breach of contract was flagrant and opportunistic. And also that it was a very short period before that she had freely and fairly negotiated the contract and not raised any concerns about the negative stipulations. And in the discussion around that, they also note, for example, that she was of equal bargaining power. She had good, she had independent legal advice, etc. Okay, let's have a look then. So, what is an injunction? An injunction is a court order restraining the commission of a wrongful act, including a breach of obligation under a contract. Okay. So in this instance, it is an order that prevents her from breaching that negative stipulation that prevented her from going to seek out employment elsewhere. Okay. What kind of obligation is it designed to enforce? A legal or equitable obligation. So it's usually a negative promise. So a promise not to do something, like go work for a competitor. Is an injunction available as of right to enforce a negative promise? No, it is not. These equitable remedies, so injunction and specific performance, are discretionary only. The court in its discretion will decide after weighing the various factors. So it's not available as of right, like damages, common law damages for a breach of contract. Oh, you can see discussion of that at 346 in the case. What we infer from this case is a major limitation on the availability of injunction. Well, the major limitation here would be that it's discretionary, although the court still found it fine, and they obviously ordered in favour of Beyond here. Okay, so next question, is an injunction available if its effect is to enforce a contract of employment? So this is that argument which was central to Curro's defence. So she argued that essentially enforcing the negative promise compelled her to carry out her obligations to Beyond in relation to this particular television show. Now, in the case, it says that a negative promise will not be enforced by injunction if that promise would have the practical effect of compelling specific performance. So essentially, if it's used as a backdoor way to getting a contract for personal services performed. And the thing here is that the courts don't want people to remain idle at, risk of destitution, which is the phrase used in the case. Yeah, so they don't want to essentially force people to carry out their obligations under a personal services contract. However, they do note that there is an exception in cases such as this one. So in the case of special services, which is, for example, the services of actors, presenters, athletes, etc., a promise not to take employment with a competitor operates as an exception, and it's the type of conduct that can be restrained. So what kinds of things then constitute special services for the purpose of this exception, which is one of our questions here? So as mentioned, it includes contracts with opera singers, movie stars, actors, rock singers, football players, and newspaper production managers. So these are just, it's a non-exhaustive list, so the categories are not closed. Now, in terms of the lack of mutuality, was that, or did the court state that's a bar to claims for injunction in cases of this kind? No, the lack of mutuality is discretionary, which is something the court makes very clear here. Mutuality is technically something that is needed in cases to get access to these equitable remedies, but in reality, it's very, courts very rarely rely on it as a grounds for rejecting one of these equitable remedies. Mutuality being both parties technically need to have the right to bring specific performance actions against each other for specific performance to be enforced or in order to be granted in favour of one party. So both parties need the right. I just had in my notes as well, in the Lumley and Wagner case, which is the case referred to in Curro, it was held that an injunction will still be granted when the balance of discretionary factors is in the plaintiff's favour, and that's even when that lack of mutuality is there. Now, what do the reasons of the court in this case tell you about the nature of the rights and obligations created by contract? In terms of this, I think that it really just shows you that these rights and obligations will be enforced by equity unless it's unconscionable to do so. So that idea of unconscionability, which is another ground we looked at as a potential bar to receiving an order for specific performance and an injunction noted earlier. There's a quote in the case which I've got here, which I'll just read to you. It states that it will not suffer them to depart from the contract at their pleasure, leaving the other party with whom they have contracted to the mere chance of any damages which a jury may give. The exercise of this jurisdiction has, I believe, a wholesome tendency towards the maintenance of good faith. So here, essentially, rights and obligations in a contract will be enforced by equity through something like an injunction, unless it's unconscionable to do so. And you can see support for that kind of idea in Curro, in the fact that the court draws attention to the fact that her breach of contract was flagrant, okay? And opportunistic, I believe, as well. All right. So I'll just leave that there.